Hey there, Legal Tea listeners. This is your host, Jenny Roselle. Welcome back for another Legal Tea episode today, episode 101. Today's topic is a current trend, and on this type of episode, we dive into something going on in the current time or that I've stumbled across on the news or social media that is pertinent to my little estate and elder law world. Today's episode is going to be about a more and more popular family setup called blended families. You know, I was really inspired to write this episode because I happened to stumble upon an article that is hilariously and perfectly titled, Comparing Estate Planning, Leave It to Beaver versus Modern Family. The article is written by a gentleman, John Goralka, and it's of course linked in the source links for this episode. I seriously think that John should win some sort of an award for coming up with that awesome title. And before we dive in, I keep hearing my smoke detector beep. Clearly, I need to change the batteries. So I really hope you guys can't hear that. And if you can, I'm so sorry. I'll get them changed before I record my next episode. Alrighty, so really talking about Leave It to Beaver and Modern Family first. I have some younger Legal Tea listeners that may not know Leave It to Beaver very well, and I have some older Legal Tea listeners that may not know the show Modern Family very well. So, Leave It to Beaver first. Oh, the Cleavers, right? Okay, so we had Ward and June Cleaver. They're the parents, and they had two kids, Wally and Theodore. Theodore specifically is really who, quote, Beaver is, and really who the show is about. Wikipedia explains it really well. They say, quote, the show is built around young Theodore Beaver Cleaver and the trouble he gets himself into while navigating an often incomprehensible, sometimes illogical world, end quote. The Cleavers were like your everyday family. Parents still married, kiddos were fine and dandy, all things considered. And as John's article notes, quote, the estate planning goals and challenges for families like the Cleavers are often less complex than those of the blended family today. I would totally agree with that. While even Cleaver-like families still have to navigate options around, avoiding probate and gaining asset protection, their family setup, their family dynamic just often requires less conversation around the people. And I'm reminded of something my husband says all the time, and some of you may know he's an estate and elder law attorney as well. We own the practice together. And he always says estate planning is not complicated. It's the people in an estate plan that often make it complicated. And oh my goodness, that's so true. Alrighty, so let's shift to Modern Family. It's like Leave It to Beaver, it's a show. And the patriarch in Modern Family is a guy named Jay Pritchett. So Jay has two children, Claire and Mitchell. And Jay, the patriarch guy, he married a significantly younger woman, Gloria. And oh my God, I love Gloria in the show. She is like this feisty Colombian woman. And her and Jay's exchanges in the show just crack me up. Anyway, so Jay and Gloria together have one child who goes by Joe. And Gloria also has a child from a prior marriage who goes by Manny. And also of note, Jay's son Mitchell is married to a guy named Cameron. And together they adopted a couple kiddos by the name of Lily and Rexford. So between all these people, this show, Modern Family, really beautifully exemplifies more modern day families, involving stepchildren and blended families and same-sex couples. And as John's article notes, families today are looking more and more and more like Jay's family. At least in some way, right? Would an estate plan for the Cleaver family work for Jay's family? Very likely not. And before I go on, I want to know also, are there still Cleaver-like families out there? Sure. I would consider myself, the family that I hail from, a very Cleaver-like family. Honestly, my parents are still married. They had my sister and I. 10 months apart. I have we're, very close in age. We are both responsible humans and good kids. There's just nothing really that unique about us. But in my experience as an estate attorney, there sure are a lot, if not more, families like the family on Modern Family, where something requires just a little bit more consideration and a little bit more conversation and thought when doing estate planning. And honestly, that's what makes my job fun and creative, and it keeps me on my toes. If everyone's family setup and dynamic was the exact same, can you imagine how boring that would get? So John referenced in his article, and like I said, a couple seconds ago, families nowadays often resemble Jay's family's setup in Modern Family. And because of that, Jay's estate plan, likely just look a little different, right, than say the Cleaver's estate plan. So John, in his article, he says, quote, "How would Jay know that his kids would inherit after his death? Could Gloria change the beneficiaries after Jay's death? How could Gloria be sure that Manny is provided for? Claire works in Jay's business while Mitchell is a practicing attorney. Should Claire receive the business and Mitchell receive other assets or insurance proceeds to balance the inheritance?" End quote. These are all very good questions, and these are all questions and topics that I have personally navigated with my own clients, and quite frequently, to be honest. By far, one of the biggest differences between the Cleavers in Leave It to Beaver and Jay's family in Modern Family is, of course, the family setup. Often, Jay's family would be referred to as a blended family. So today, since it's a current trends episode, and in my experience and in my law firm, I'm just seeing more and more blended families. So I figured it would be a great time to do an episode here on Legal Tea on blended families and things for blended families to consider when embarking on an estate planning venture. So let's dive in. If I had to list out the top 3 things that I hear blended families reference in one of my meetings as like a concern or as a goal, those 3 things would be: first, making sure that at the first passing, the surviving spouse does not yank out the deceased spouse's child or the children or beneficiaries. Or maybe a better or easier way to say this is that the surviving spouse can't really change much of the estate plan after the first passes away. Second, they also often want to make sure that at the first passing, if they, as in the spouses, have actually kept things separate, like kept assets separate. And I see this often in later in life marriages. So call it like 50 years old plus. So 50 years old plus getting remarried or getting married. That the kids and beneficiaries of the deceased spouse do not kick out the surviving spouse out of like the family house. And a third thing I hear all the time from blended families as a concern or as a goal is simply making sure that because of the blended family setup, that they want the kids or the beneficiaries that like the estate plan just spells things out, ideally to make things easier and ideally to lessen the risk of any of them fighting with one another. There are, of course, many other considerations in estate planning for blended families, but in my experience, those 3 are the most popular ones that I hear. Usually, at least one of those are stated, if not 2, and if not all 3 of them. So I say we briefly discuss all 3 because I think all 3 are super important to know and understand. So first was making sure that at the first passing, the surviving spouse does not yank out the deceased spouse's children or beneficiaries. Or like I said, maybe an easier way to say all that is making sure that the surviving spouse can't really change much of the estate plan after the first passes away. So this is seriously a legitimate concern. And if I had to give an answer that was like short and sweet, which I'm going to have to here since my episodes are short and sweet, it would be this. making sure that nothing like that happens is just going to require more estate planning than just a will, like just a last will and testament. And here's why. If you leave your spouse as beneficiary on assets, or you make the spouse the joint owner of assets, those assets are going to be totally the surviving spouse's at the first passing. And that happens legally by default. It's not the will that is making that happen. It's because joint assets and beneficiary designations trump a will. And there are a few exceptions to that, but not that many. So, and actually may carry that forward. So then at the second passing, it's the second passing, that person's will is what's governing. And they could absolutely have changed their will after the first one passed away, right? So a trust is commonly used to prevent changes because with a trust, you often make the trust the owner of the asset or the beneficiary. Then at the first passing, the trust controls, and the trust can dictate and say something like, at the first passing, the survivor shall not have the authority to make amendments in the trust, et cetera, et cetera. So if this is a goal of yours or something that you want, that you're concerned about, make sure you talk to an estate planning attorney because a will is probably not going to be sufficient. Okay, moving on to the second consideration, and that was making sure that at the first passing that they, as in the spouses, if they've kept assets pretty separate, and like I said, I usually see this in later in life marriages, that the kids and beneficiaries of the deceased spouse do not kick the surviving spouse out of the family house. So much like in that last consideration that I was just talking about, this can easily be accomplished by giving the surviving spouse what is called a right to reside in the property. This can be done through a will or a trust, though with a will, it's likely going to require probate to enforce the provision. So what I meant a second ago when I said kind of like the last consideration, oftentimes a trust is what gets used because we can use it to give the spouse the legal authority to reside in the property and spell out who's paying what and what provisions are around, this authority to reside, like maybe the surviving spouse wants to move out or what happens when they pass away. And we can do all of that without the probate court involvement through a trust, not through a will. So do know that accomplishing this can be done through a will or a trust. But again, just use a good estate planning attorney to kind of navigate through that so it fits your situation the best. Lastly, the third consideration I mentioned was, quite simply making sure that since it is a blended family, kids and beneficiaries, that they have an estate plan that is spelled out, ideally to make things easier and to lessen the risk of any of them fighting with one another. And that sounds easy enough, right? So here's the theme for today, I guess. Can it be done through a will? Sure, maybe, probably. I'm sure you love that uncertainty. And, what I would say about that is that uncertainty goes away with the trust. And hear me loud and clear. I'm not a trust mill. My firm is not a trust mill. We don't just crank out trusts every day for people. There are plenty of clients that do wills, but sometimes situations just lend themselves better with a trust. But what is a trust? A trust just gains you my head went like a million different ways there for a second. A trust just gains you a lot of options and a lot of benefits that are often unattainable through a will or just really hard to attain without a trust. So my message on this consideration is that the beautiful thing about trusts is you can spell out every single step on what happens at the first passing, what happens at the second passing, who gets what in what manner. And we can even put an awesome no contest provision in there. So if they start, fighting, then they're in trouble. There are just a lot of options in trust planning. And one super quick thing before I wrap up, Before you head to your estate planning attorney appointment, if you're a blended family, be sure to have the difficult conversations and think through the difficult things before the meeting. Put some thought into what you want to see happen. We, the estate planning attorneys, have a lot of tools to support you on what you want to see happen. But we don't know your family, and we don't know your spouse, and we don't know what you really, really want. That's got to be you that decides that. And sometimes that's really hard. I know it is. Alrighty, I am out of time, my friends. So let's wrap this episode up. Next week's topic is on estate planning of the rich and famous. And on that episode, we're going to dive into what happened estate-wise following the passing of she doesn't even need an introduction, but the super famous singer, Tina Turner. She just passed away this year in 2023. But there is some kind of things going on that I thought would be kind of interesting to talk about. So, and it'll be a really nice follow-up to this episode because guess what? She was part of a blended family. And I'm telling you, more and more and more, it's just more and more normal now. So, yeah, we will dive into Tina Turner's estate next Tuesday, Legal Tea listeners. So, talk to you then and stay well.